Okay, hello class. This is Mr. Allen again. This is an introduction to physical therapy again, and today we're going to go over laws and regulations. So this is chapter 7 in my book. It should be the same in your book. If it's not, it should be chapter 8, but it should be chapter 7 if it's still the same as last semester. These are going to be laws and regulations that we go by in not just in the medical field, but also we're going to talk about laws and regulations that are specific to us too in the physical therapy world and how they affect us and our patients too. Okay, let me move these things around. Okay, laws and regulations. Okay, so there's 4 primary types of laws that we're going to talk about today, and we're going to go through each of these. Those are constitutional laws, statutory laws, common laws, and administrative or regulatory laws. And we'll start at the top. So constitutional laws are the most superior laws. These are laws that were developed from the Constitution of our country. So an example of constitutional laws are things like the Bill of Rights. So rights to free speech, right to be free from unreasonable searches, things like that. Basic rights and things like that, or anything that was in the Constitution is a constitutional law. And then just to give you an example, state constitutional laws are always going to be subordinate or under federal constitution laws, because the country we all know our country has a constitution, but each state also writes its own constitution. So state constitutional laws are inferior to federal constitutional law. So federal will always win over state. Okay. The next type is called statutory laws. These are second priority laws after constitutional laws. These are laws that are written, but were not part of the Constitution, things that have been added on to law. So things like Medicare and Medicaid. These are all things that affect, these are all laws that affect us. Let me say that. So when Medicare and Medicaid came into effect, that greatly affected us because that gave us so many more patients to see and more types of facilities to work in. Workers' Compensation Acts what the law was written that if you get hurt on the job, then your employer has to pay for your medical costs and your rehab. The ADA, the Americans with Disabilities Act of 1990, this was a big deal when this went into effect, and this really gave a lot of rights and things, and really made the playing field equal across the board in our country for those with disabilities and those with no disabilities. I shouldn't really say made equal playing field, but it tried to equal the playing field a little bit in everyday life. There was the Rehab Act of 1973 and the Individuals with Disabilities Act of 1997, which we'll talk about in a minute. Okay, the third kind of law is called common law, and these are laws that are created by judges or by trials. So say that anything that that you go to trial on something, and whatever the judge or the jury declares will be the law for you. Or say for the Supreme Court, when the Supreme Court hears cases, they often not only hear the cases for the defendant and the what's the word? Oh my gosh, I can't even remember. I watched all these court shows and I can't remember. The defendant and whoever else it is. A lot of times when the Supreme Courts or Court of Appeals around the country make rulings, those rulings don't only affect the defendant and whoever is bringing the case against them, but it also will make a law which will go into effect for the country or into an effect for the state, depending on or the area if it was an appeals court. So an example is like when, and I'm just thinking of this example off the top of my head, when the Supreme Court heard a certain trial a few months ago or a few years ago. It was just about gay marriage and a baker not wanting to make a cake for a couple. And then they heard the case and then they just made gay marriage legal through the whole country. And so that's an example of a common law authority. That was a law created by the judges. It's not in the Constitution, but it's a federal law. Also, things like malpractice law are common law, because malpractice law having to do with medicine, and then malpractice also doing illegal practices were also usually guided by judge decisions as through things that have happened in the past. A lot of times, you don't really make new laws and rules until a situation comes up that needs it to be addressed. Okay. Administrative or regulatory laws. These are enacted at the local, state, and federal level. So there are local, state, and federal. Think about local, they influence business conduct. So say like charging the right amounts for your sessions and your copays, not overcharging patients for their sessions and charging them for their copays, like say doubling their copay when it's only supposed to be $20. That would be against that law, that regulatory law. A lot of the regulatory laws are in place in healthcare because it helps guide our practices, like our scope of practice, what a PT can do versus what a doctor can do, and then our research and education also. So administrative and regulatory laws have a lot to do with our practice every day and with our education too. Other examples, like federal examples, are like OSHA and CMS. OSHA is the Occupational Safety and Health Administration that basically oversees safety in basically every workplace that there is. We think about OSHA being real important for factories and for places that build really big machinery or places that it's on assembly line. But OSHA is really important for all workplaces. I mean, we even at PIMA, we're a school, but we have OSHA guidelines that we have to follow. And believe it or not, that rule that we have, no food or drink in the lab or the classroom, that is an OSHA guideline, if you believe it or not, because this is considered, our lab is considered a healthcare learning facility. So there's supposed to be no food or drink. So it's an OSHA guideline. Center for Medicare and Medicaid Services, CMS, is just a regulatory law that's a federal law that just helps us to, it gives guidance for seeing people in certain ages or certain financial situations, and then we'll have guidance on how many sessions we can have and things like that. Okay, let's talk about certain laws now. The Americans with Disabilities Act. I said we would come back to this. This was passed in 1990, and this is a non-discrimination law that and I'm just going to read this word for word, and then we'll talk about it. It prevents discrimination against people with disabilities in the areas of employment, public accommodations, government services, and telecommunications. So this just means when the Americans with Disabilities Act was passed, it meant that it's a non-discrimination law so that people with disabilities, with any type of disability, physical, mental, and no matter what degree, that as long as it's safe, that you have the same rights and chances for employment, to get jobs. Public accommodations means like hotel rooms, getting an apartment, things like that. State and local government services, so being able to get all the government services that are available to you, and telecommunications. So take you might wonder why telecommunications is in there. Well, take deaf people, they can't hear, but way before text messaging and smartphones, there was a way, and I never understood it, but it was a way that it was like, I think it was an early type of text messaging, but it was called like teletypewriters, where a deaf person could have a conversation on the phone with a hearing person, but there was an operator in the middle that was doing the translating for them. And I think the operator would translate the speech from the guest on to the deaf person. It would come out as words or on a screen, it would type out on a piece of paper. That's very actually old technology. I don't even know if that is even used anymore, because text messaging and email is so prominent now. I don't even know if that's around anymore, but it might be. I think it was called a teletypewriter, but that was a long time ago. I've never even seen one. Public accommodations, so that take in Houston, the metro, so the bus system. A wheelchair user can't get up on those big buses, so they have to have buses that are wheelchair buses, and they're called, in Houston, those are called metro lift bus, and they're small buses, but they have a wheelchair ramp on the back that the doors open up and the platform unfolds and it comes down. Person drives onto the platform, and then it raises them up hydraulically, and they drive into the van or to the bus. So people that have disabilities have to have the same types of chances for transportation that we do. What else could we talk about here? I said public accommodations. Hotels have to have certain percentages of their rooms that they build that are wheelchair and handicap accessible. So they have to have a certain, from inception of the building, from when they start drawing the plans. Now, this is after the Americans with Disabilities Act was enacted. If you didn't have these before the act, you were just grandfathered in because the building was already built. But now any building that's built has hotels, apartments, federal buildings, state buildings, they have to have perfectly fine and safe access for those with disabilities and in wheelchairs. Hotels and apartments have to have certain percentages of their units that are like a roll-in shower, so that somebody in a wheelchair that needs to be on a shower seat could just, there's not a bathtub, they just roll in on their shower chair that has wheels. And it has bars so they can hold on to when they're doing their transfers in and out of their wheelchair, things like that. I won't beat this horse anymore. Okay, we'll still talk about the well, this is more about the ADA, and it's a little bit, I did go into this a little bit. It did protect against employment discrimination. We'll talk about that a little bit more. So things that an employer has to be able to make accommodations for a person with disabilities. So if you go out and you say you're in a wheelchair and you want to get a job, so anywhere doing something, your employer has to make accommodations for you legally to be able to get, if say for your wheelchair to fit in the doors and to get around the office. Now, and they're obligated to do that legally, and they can't just not hire you because you have that disability. But the one way they can get out of that, if they can prove that making those accommodations for you, for the disabled person, would be a financial hardship on them and their business, then that's considered that's considered reasonable, and they don't have to follow the guidelines. Then if they can prove that that's going to like cut out like all their savings of their business, or it's going to really put their business under for a while, then you can get out of it. And then that way, I don't know what happens then. Either the person can't work there, or they work there in a different manner, or they just get another job. But that's the way the employer can get out of it. But you got to really show proof. I mean, you can't just talk to somebody on the phone and say, sorry, I can't afford this. You've got to show some financial documents, and then you've got to have things to prove that you cannot make those accommodations. And I'm talking about things like installing a ramp, widening doors so that a person with a wheelchair could get through the door, making restrooms more accessible, making stalls bigger so that a wheelchair could fit in the stall and turn around so the person could use the restroom, making a certain parking area accessible for handicapped people. giving people time off if they have a disability, like if they have to get a lot of medical treatment or therapy for their disability, then the employer must give them time off for that, because that's part of their disability, and the employer cannot, under the ADA, cannot discriminate against that unless they can prove that it's a reasonable hardship. And I think it's pretty hard to show that. We already talked about public transportation. So you have people with disabilities are supposed to have equal access to public services. That's transportation, public medical care, things like that. Then we have Title III, which is accommodations like hotels, apartments, even restaurants, grocery stores, libraries, museums, even theaters and shopping centers have to have accommodations for people in wheelchairs. If you think about it, if you've ever been in a movie theater, most movie theaters, most of us have not been in a movie theater in about a year now because of the pandemic, but if you go, next time you go in a movie theater, look up at the very top row, there's going to be a few chairs that they're sectioned off and spaced out. Those are for people with disabilities, and they have a special elevator they ride up to the very top of the theater, and then there's chairs there. There's places for wheelchairs to park, and there's places that people that still are ambulatory but have gait deviations, they can walk and the rows are really wide and there's space between the seats, so they have plenty of room to get around their seat and to hang on. We talked about telecommunications. I talked about that a lot. Okay, now that's all in the ADA. The Individuals with Disabilities Education Act, or IDEA. This was passed in 1997, and this just states that all children with disabilities have the right to have free and appropriate public education that is designed to meet their unique needs to prepare them for employment and independent living. So what does that mean? In English, that means that kids with disabilities they have the right under the federal government to get free public education that meets their specific needs, physically or mentally, whatever their disability is, and they're still supposed to be prepared for employment after they get out of school, or independent living by themselves. Now, if you think about it, think about what you know about when you were in high school and elementary school, what special ed classes were like, or those people that I remember. There were people with disabilities when I was in high school that were in the special ed class, but I just remember there was one special ed class for the whole school, and all those people were mixed in together. Well, not all those people had mental disabilities. Some of them had physical disabilities, but they were put in special ed because they couldn't get themselves to and from regular classes, like in their wheelchair, fast enough. Like it might take them 15 minutes to get from one class to the next. So they were put in special ed. That's not right. That's not what's supposed to happen. People, if a kid can stay in a regular class and learn, then by law they need to stay in a regular class and learn. So if their problems are just physical, then they have the right to stay in a regular classroom. So that's why we have therapists that work in the schools. Therapists will work with teachers to get students special desks. So if they have head control problems or trunk control problems, the special seat will help sit them up. Some students stand up with a special device that they stand up and they have a tray in front of them and they do all their work or on their laptop or tablet in the back of the room while they're standing in a standing device. And that's part of their therapy, is standing every day, but they do it while they're in class because they're getting a 2-for-1 deal. So kids that don't have any cognitive disabilities, they really need to be in a regular education class. Now, Texas is a lot better about that. Kids with disabilities, therapists really work with them to stay in regular classes. Now, I'm from Mississippi originally, and that's where I went to elementary and high school, and it was not like that there. I never remember seeing any kind of therapist working with anybody or helping to keep somebody in a regular class. I mean, if a kid had any kind of disability, they just went into special ed, and I'm sure tons of those kids just fell through the cracks of society over the years because those classes just were not made for them, and they just didn't teach them how to get prepared for the world and to be independent adults and even get ready for college. So I think that did a lot of those kids that I grew up with had a disservice done. Texas is better since I've been here and been a therapist. I see it and hear about it in the schools, and it's better. But just think about that. If you ever work in the school system and you see a kid that's in special ed and you think they probably need to be in regular classes, you can say something if you work for the school district because you're part of that school district. You're part of that team. Okay, I talked a lot about that. Sorry. PT for services for kids with disabilities. So we do a lot. We do a lot of screening and evaluation and assessments of infants and toddlers. Any baby that's born that they think that they might be, if they're premature, usually more than a couple, if it's more than a few weeks, they might have a PT come and do a motor assessment to check for reflexes and to check for things like that to see how their muscle tone is. As infants grow, if they're developing slowly, we work with infants and toddlers on reaching developmental milestones like sitting up by themselves and crawling and then eventually standing and walking, things like that. Providing treatment to alleviate or compensate for movement dysfunction. So all kids that have a movement problem or neuro problem or something that affects their movement, we're going to try to make things where they don't compensate. And that means where they don't try to create shortcuts or different motor patterns to accomplish the same task. So when I say somebody might compensate, if somebody walks and the only way they can walk is by walking with a really big and ugly limp, and that's the only way they can walk, well, that's called compensating. Now, when we start treatment with anybody of any age, we never want anybody to compensate because our jobs as therapists are, because if we weren't around, everybody in the world would learn to compensate, and they would learn new movements and new movement patterns, and they're not the right movement patterns, and the brain would wire itself to move in the wrong way, and they would just develop new problems. They would never walk right again. So our job is to get people to not compensate, to move the right way to get better. Kids always are going to try to compensate. So we're really always big on trying to get them to do things the way a regular kid would do it. And then any kid that's going to be in treatment is going to have a whole team of therapists and other practitioners with them. There's going to be therapists, there's going to be social workers, there might be play therapists, music therapists, and the teachers are just as part of their plan as the doctors are. And don't forget about the parents too, because the parents are with the kids 24/7. They know them better than we do. So let your parent listen to your kids' parents too when they tell you things about things that happen with their kid, because they can a lot of times tell you way more than the parent can. Okay, switching gears. PT and PTA licensure laws. Basically, we have to have a license to practice. You know that. So PTs are licensed in every state, plus DC, Puerto Rico, and the U.S. Virgin Islands. Well, for some weird reason, PTAs are licensed in everywhere that I just said PTs are, except Hawaii and Colorado. So that's 51 jurisdictions. And then the PTAs that work in Hawaii and Colorado can still practice, but they're not licensed. Now, I have no clue about their Practice Act in those two states. I don't know why they don't let PTAs get licensed, why they don't think they should get licensed. I mean, with the education you guys are going to get when you're done, I think you deserve a license after what you're going to go through, and with the type of responsibility you're going to have with your job. Yeah, it's important that I think everybody should have a license. So I don't know what's going on with those two states, but yes, in Texas, you do have to have a license, and you do have to maintain it every 2 years, and that's very important. This is just a little bit on OSHA, just makes things safety and protects workers and also patients from harm, makes healthy and safe working conditions. Bloodborne pathogen training is part of OSHA. This is a link to a video. I don't know this link works anymore. You can watch this today if you want to, if this link works. I'm gonna have we'll either watch the same one or I'll have a different one on the following class that we'll watch together. OSHA also, OSHA has a lot to do with the immunization programs that we go throughout life, like when we get organized. OSHA helps a lot with mass immunization programs. So I'm sure right now, well, I don't know, really, honestly. I would think that right now, that OSHA is helping a little bit with the pandemic, with the COVID vaccine rollout, but I haven't heard anything about OSHA acting yet. It's been mostly the CDC and the military. But OSHA came up with proper medical hand washing, the handling of like old needles and scalpels and things. We put them in we call it a sharps container, so they can never be, so it cuts down on the danger of somebody getting a needle stick or cut again accidentally. Disposing properly of medical waste and anything that's been soiled or has blood on it or other bodily fluids. Protecting yourself against infection if you have a patient that has an infection, disinfecting areas properly, proper training programs if you're going to be doing transfers and doing suctioning on patients, if you're going to be working in a hospital with people that have trachs and things like that, those types of things. Universal precautions just means basically you wash your hands and keep yourself clean, and you kind of act like, and you use gloves for universal precautions. You wash your hands before and after every patient, gowns sometimes, but basically universal precautions are not just to protect the patient. I mean, not to protect you from the patient. The universal precautions are basically for the same reason that we're all wearing masks right now. We protect each other from each other. With universal precautions, I'm protecting the patient from myself. And then if the patient is washing their hands and keeping clean, they're protecting me from them, if that makes sense. This is pretty self-explanatory, unless you read this. A little bit changing gears a little bit, but still kind of on the legal issue. We do have a little bit of have an obligation to report things like domestic violence, abuse, any kind. If we think somebody that's in our care is being threatened or intimidated by somebody emotionally or physically or psychologically, if we think somebody's being abused verbally, sexually, or physically or psychologically, we have an obligation as a practitioner in our world to report that. So you as a PTA, if you see those things and you see those signs, you need to report those things. Now, I'm not saying you might not, it's probably not a good idea just to come out if you suspect something and say, hey, is your husband abusing you, to your patient? That's probably not a good idea, because they're probably going to deny it, and that's probably not a good way to bring it about. But if you have a patient that you think is being physically abused, like maybe they're always coming in with bruises, or maybe they have an injury they're seeing you for, and that injury is just not healing the way it's supposed to, or it keeps getting re-injured, or somebody that maybe their spouse always comes to them to therapy, and their spouse is always, you can tell their spouse is always telling them what to do and always wanting to speak for them and never gives them a chance. Maybe get your patient, maybe when you have a moment alone for your patient, just ask your patients, everything okay at home, blah, blah, blah. You feeling okay? Anything wrong? Sometimes you have to ask these things very, very sneakily. We have to be very sneaky if we suspect any of this, but it is our job to try to find out. And, if you're not going to ask your patient, then if by anything. Ask your supervising PT. I mean, you've got to report any suspicion to your supervising PT anyway, but if you don't ask your patient, if you don't feel comfortable asking your patient, or you're just not sure, report to your PT, and maybe y'all can come up with a way to do it together or to investigate together. But yeah, we do have this is very big. We do have to report this. So signs of abuse could be chronic pain that doesn't go away, injuries during pregnancy. So I mean, it's not very common that pregnant women get injured. So, I mean, they do. They can bump their elbows. They can sprain their ankle. They might fall. But if a lady gets injured during pregnancy, that's usually a big deal. I mean, we're checking her out. She's getting checked out medically, but we're gonna just let that throw up a red flag to you if somebody that's pregnant gets injured. Somebody that gets repeated injuries, not just somebody that's just uncoordinated and just a klutz, but somebody that just has repeated injuries and it's just not explained, or they always seem to be making up excuses. Maybe if they have a chronic illness that they're not controlling very well, maybe that could be a sign. If they're pregnant and not seeing a physician for obstetric services, maybe that's a sign that there's some verbal abuse, or maybe there's some threats going on, or maybe there's some disagreements between the parents about the pregnancy. That's always dangerous. And also for just women, unintended gynecological problems. If they're having problems and they're not taking care of it, well, why? I mean, is it because somebody in their family is keeping them from getting taken care of, or is it truly the patient just doesn't understand or care? We got to figure that out sometimes. And physical symptoms related that are coming from stress, anxiety, or depression. I mean, if our patient, it's going to be common that our patients are depressed because if they have injuries, or especially if you have a neuro patient, they're going to have a lot of impairments and maybe some disabilities. So yeah, it's common for them to go through depression. But people that are developing physical symptoms because of stress, anxiety, or depression, like maybe their sleep patterns are changing, or their eating patterns are changing, or they're just having a lot more fatigue or just overall pain everywhere, and they seem to be more anxious or depressed at the same time, that's a sign that something's going on at home. That's not just regular depression, anxiety. That's a sign something's going on at home. Probably we need to look into that. If you have a social worker on your team, I would go to them first if you can't figure it out, because they are trained to recognize these signs a lot better than us, and they know how to handle it, and they know how to bring it up with people. So if you have a social worker on staff, use them. They're going to be your best friends. Learn from your social workers. They will teach you things. They'll teach you resources. They'll show you resources to send patients, but they're going to be your best friends for things like this. If you just have something going on weird with your patient that just doesn't seem right, social worker can figure it out. If somebody else on your team hasn't figured it out already, ask social work. Other civil laws that were derived from common laws, and these are malpractice laws. So this is healthcare malpractice, and we've all heard of the malpractice insurance that doctors have. Well, we have malpractice liability too. That's usually paid for insurance malpractice insurance. We all have to have it. Usually paid for by our facilities, unless you're a private practitioner, then you pay your own. But this just protects you against negligence, misconduct, dangerous treatment activities, or things if the patient was injured. So this does protect you if something happens. Now, what is considered professional negligence and intentional conduct? Now, those are two bad things. Those are things that should never happen. Now, patient injury from a dangerous exam or treatment related activities, it shouldn't be something that is they shouldn't get injured from something that is contraindicated that they shouldn't be doing anyway. But sometimes we're going to be doing something with a patient, an exercise or a treatment, and it should be perfectly safe for them. But something happens and an injury might happen. I mean, things are going to happen sometimes in life. Or maybe there was a hot pack that was defective and you put it on the patient and you put the right amount of insulation on there, but the hot pack was defective and leaked on the patient a little bit and gave them a little burn. I mean, yes, that was partially the facility's fault because you used a faulty hot pack, but you didn't do that intentionally. So it was an accident. It was a defective product. Those are things that malpractice insurance will protect you from. Now, things like professional negligence, if you're just neglecting your patient and not doing what you're supposed to be doing, and we'll define negligence in a second, then that's just flat out not being a good clinician. That's wrong, but you can get in trouble for that. And especially intentional misconduct. If you do something if you intentionally break a law or break an ethical code of conduct, then that's not a black and white area. You can get in trouble for that. So what is negligence? Okay. Negligence is failure to do what another competent practitioner would have done in the same circumstance. So an example is causing a burn injury from leaving a hot pack on a patient too long. Well, you'll learn next semester, hot packs, if you have the right amount of insulation to keep the skin protected, then hot packs should never stay on a patient. No, never longer than 20 minutes. That's the longest they need to stay on there. If you left a hot pack on too long, you could burn the patient. If you didn't put enough layers of insulation, you could easily burn the patient. So those are things that any other competent practitioner would have gotten right. So if you don't do those things, that's just considered negligence. Or if you don't give the right kind of care to the person, if you just kind of, the kind of care you need to give them, but you're feeling lazy that day and you've had a hard day and they're your last patient of the day, and you're like, you know what? I don't really want to work hard today. I don't want to think hard in this last session. I've been working hard. I'm just going to let them do the bare minimal today, the bare minimal exercises, and just get through the hour. Well, that's not reasonable care. That's not doing anything for the patient. So, I mean, if the patient picks up on that you're just doing something to get through the hour, then they can bring that against you. Another thing that goes with negligence is the term duty of care. That's treatment using common standards of practice that are expected in our community, in our profession under similar circumstances. So let's go back to that hot pack injury. The common standard of practice would be to check your hot pack to make sure it doesn't have a leak or an up tear, and then to use the proper amount of layers of insulation. If you don't do that, then you're not providing duty of care. Another example that we have here, if you have a THA, that stands for total hip arthroplasty, or a hip replacement. So when we get a hip replacement, there's precautions that we have to go through after surgery, certain movements and certain ranges and certain things that we can't do until we're healed, so that our prosthesis inside the body doesn't pop out of place and let everything heal, the bone heal around it. Well, if you don't educate your patient on those precautions, you're not providing the proper duty of care. Your peers would have given that, and that's common basic information that you didn't provide. So you neglected your patient, and you're going to get it. You probably should get in trouble, because if they get hurt because you didn't warn them, then it's your fault. So this is 4 circumstances that are necessary that have to prove negligence. That legal duty of care was established. So they have I'm sure that so let's just say worst case scenario, you have a case brought against you. The lawyers are going to look at your scope of practice and then the patient's diagnosis, and they're going to say, okay, this is what usually a duty of care, the plan of care should be should look like. And these are the things that are usually done for this type of patient. This is the type of education that is given to this patient. Then they're going to look at your documentation and then the patient's complaint. Well, then they're going to see something happened in this duty of care where something didn't go right. The patient is saying maybe it's the patient's is saying it's your fault, or maybe it's that you didn't do something right. It's one or the other. We'll look at number 3. Because of the breach of duty of care, because you didn't do something right, injury was caused to the patient. And then because of injury, harm resulted from that injury. So it could be a new disability. It could cause a progression of their disability. It could be an injury or a surgery they're seeing you for, and it causes more harm to that scar or to that healing, or maybe causes a new injury or something, or re-harms that or re-injures that same site, something like that. If they can prove all of that, then yeah, you're pretty much up the creek without a paddle. They got you. You're going to get in trouble. But that's why when we talked about, let me go back, this is kind of going off topic, but this is going back to when we talked about documentation and SOAP notes. Everything that happens in a session, whether it's planned or not, even if it's an accident, if something happens to the patient or they get hurt, you have to document it. Now, a lot of times an accident like a fall, you're not gonna, you have to ask your facility. Some facilities are gonna want you to put that in the medical record. Sometimes you put accidents in a risk analysis or risk assessment documentation, and you keep that separate. Now, people can still look at that documentation, but it's not part of your usual medical record. So some facilities do it a little bit differently. But if they can prove that harm resulted from the injury, you could get in trouble. So you'll get in trouble, and your supervising PT that signs off on your notes could get in trouble too, because if they signed off on your note after that treatment session, well, they signed off on it, and their signature shows that their signature says basically, I agree with this, with what this PTA did. And so now if harm resulted, then you're both in trouble. But if, say that you documented it and then the PT refused to sign it because of the harm, then the PT is okay, but you're going to be in big trouble. The PT will probably have to go and talk on your behalf in court, but the PT refused to sign it because you did something harmful or went outside of your scope of practice or plan of care. I've talked about this a long time. Let's move on. Examples of malpractice acts in PT: burns are probably the most common. Defective equipment, falls are really common, and patient exercise injuries, just like overuse injuries. But I would say in my world, in the neuro world, from where I came from, falls were the most common things that could happen. And, you know, when you're working with neuro patients, I mean, you never want a fall when you're working with them is a big deal. You never want a patient to fall with you because you got to document stuff. It's extra paperwork. You've got to make sure they're okay, they're not injured. And plus you never want your patient to fall. You don't want the patient to see and to kind of have that opinion of you in their eyes, but things happen. Okay, people are weak. If you're walking with a 200-pound person you're holding up their body weight with 3 people, it might happen. I've seen it happen in therapy. And also, you need to tell your patients that outside of therapy, if you're a neuro patient, you're probably going to fall one day. So we need to learn how to get up. So maybe sometimes you might practice falling and then how to get up from a fall. That's going off topic way a lot. I'm sorry. Let me get back on topic. Patients have a statute of limitations of when they can make a claim on the injury. It's different with different states. So that's why this says 1 to 4 years. But after the statute, if you don't know what a statute of limitations that means, what it basically means, let's just say the statute of limitations in Texas was 4 years. So let's say you had an injury or something happened to you in therapy, and then you had harm from it. Well, then 4 years, you never report it. Well, then 4 years later, you're still having problems and you decide, well, you know what? I think I'm going to make a legal claim against that therapist that did this to me. Well, the statute of limitations is up. You had 4 years to make your claim and it's up. So now it's too late. You can't do anything. That's what statute of limitations basically means. But this is going to be different for us for PT in different states. It's going to be different with doctors too. It's going to be different with different practitioners. And anything that's outside of the APTA's ethical principles and standards of practice is also going to be considered a malpractice too. So even though if we're not causing like physical harm to the patient, if we do something like, say, we get into an inappropriate relationship with our patient, say we meet this patient and you're working with this patient and, you know, your personalities match and you get along pretty well, and after a few sessions you're getting along really well, well then you decide to ask, sorry about the dogs, you decide to ask your patient out on a date. That's a big no-no. While you are a patient, somebody is under your care, you can have no other type of relationship or contact with them whatsoever. Now, if you did date your patient, or let's say you did go into an inappropriate sexual relationship with a patient of yours, you're not going to go to jail because you're not breaking any federal law, but you're breaking a lot of ethical principles and standards of practice. So you can lose your license. You can lose your license. You can have your license suspended. Most of the time, they just will give you a warning. You might have your license suspended for something like this for a few months. You might have to do community service. Something like that, but yeah, you can have your license suspended or revoked for different malpractice acts. It just depends on what the board deems. The state boards do all that. They make in all those things when they have to do something with a license, it's all reported publicly. So it comes out in a newsletter every month, and they show, and I see it every month. I see all the PTs and PTAs in Texas that got in trouble and what they did. And most of the time, it's just forgetting to renew their license. They go 2 days and they remember they've been practicing for 2 days with a expired license. Well, that's a big deal. That's a law they're breaking. So they have to report themselves, and then they have to report the patients that they've seen with an expired license, and they'll probably get their license suspended for like a month or two. And then they do community service, pay a fee, and then they're back again. Somebody that does something maybe like go act inappropriately, maybe act outside the scope of practice, like I saw in one newsletter where a PT was giving CBD oil to one of his patients for pain relief. Well, CBD oil is legal in Texas, yes, but a PT is not a doctor. A PT cannot recommend medication. A PT cannot recommend anything like that. We can't even recommend, anything drug related. So he was way outside of his scope of practice. So he lost his license, I think, indefinitely, this guy. But that's pretty stupid. He should know a lot better than that. So I think he kind of deserved it. Anyway, that's all on laws and things. So I gave you a lot of examples and went up on a lot of tangents, but hopefully with my examples, you learned a few things, and you learned just not to get in trouble, or you will have somebody after you one day. But the moral of the story is, if you're safe, if you always keep safety in mind with your patient, and you do what you know is the best of your ability, you're going to be good and you won't get in trouble. Just don't be negligent. Always do, like we talked about the other day, do the best for your patient all the time, and always try to be safe, and you should never get in trouble. Okay. All right, if you have any questions on any of these laws or any of these acts, or if any of my examples confused you, you know how to email me, you know how to get in touch with me, and I'll be there during your open lab, so you can talk to me then. Thank you.